A very good evening, madam. With your permission, shall I please proceed with the session?
Yes, please.
Sure. And it is again lovely to see you.
Same here.
A very warm evening to everyone. It is with great pleasure that I welcome you all to today's special session on art of drafting divorce petition and application. This event holds particular significance as we also celebrate the fifth anniversary of Legal Expatriate, a platform that has been instrumental in providing comprehensive legal education and resources to students, researchers, and professionals across India. Over the past 5 years, Legal Expatriate has organized numerous courses and competition, fostering a community dedicated to legal excellence. Today, we are honored to have Ms. Medha Singh ma'am as our esteemed guest speaker. Ms. Singh is a distinguished lecturer at the School of Law, Forensic Justice and Policy Studies at the National Forensic Science University in Gandhinagar, Gujarat. She holds a BA-LLB honors from Amity's Law School, Lucknow, and an LLM in criminal law from the Institute of Law, Nirma University. Additionally, she has completed a postgraduate diploma in criminal law and forensic science from Nalsa University of Law, Hyderabad. With over 4 years of teaching experience, Ms. Singh specializes in criminal law and its allied disciplines. Her academic pursuits are complicated by her contribution to research, including publications that explore the integration of forensic science within the criminal justice system. Her expertise and insights make her an invaluable resource for today's session. Please join me in extending a warm welcome to Ms. Medha Singh. We look forward to an engaging and informative session. Thank you. And thank you everyone for being so consistent with us so that we are able to complete this 5 years of journey with all of you. Hope for the betterment of everyone in the coming years.
May I begin?
Yes, ma'am.
All right. Thank you so much for that generous introduction. Very good evening, everyone. Just to put your minds at ease, I can vouch for one thing now that as of now, I have been consistently teaching family law for 4 semesters. So you are in safe hands, studying matrimonial clauses under personal laws in India. So, without further ado, let us begin. For the sake of your own understanding and for the sake of your own ease, if you have Bare Acts with you, that would be wonderful. If you don't, if you have access to a device in which you can look over the sections that I will be referring to, that will be great. So, let us begin the class. So, I'm going to be discussing the concept of judicial separation under the Hindu, Muslim, as well as Parsi law. I will be discussing the various legal provisions of divorce under various personal laws. What are the grounds and what is the intricacies of divorce under various personal laws operating in this country? And obviously, I will be starting off with conceptual clarity, moving on then to the specificity of provisions. So, like I said, if you can have the Bare Act with you as and when required, that will aid you quite a lot in understanding. So, without further ado, let us begin. Judicial separation is actually a process in which a couple is formally separated, but they are not, their marriage has not ceased to exist. So we're starting off with explaining the fact that let us take a couple, we are calling them H for husband, W for wife. For the sake of understanding, H and W will be our two illustrations for the rest of the class. So H and W are two Hindus who are married, and they are they followed all the essential valid conditions of marriage and they're married. Now, marriage is now not an indissoluble union anymore. So they want to proceed with dissolving their marriage. But it is the intent of the laws, all personal laws that govern marriage, that marriage as an institution must not be dissolved. It must be saved, it must be protected. So, for that respect, there are multiple provisions that are present that stop the marriage to get to a point where it is actually getting dissolved. One such provision is judicial separation. So, two spouses, heterosexual spouses, husband and wife, are separated from each other. They are spouses of each other. They are still married, but they are separated. Now, this is what separation is, obviously. Why are we calling it a judicial separation? Because you have to go to the court and ask for a decree to declare that you have separated. Even though you are still spouses, you are separated. So it is a process by which a married couple is formally separated despite being legally married. So first thing to remember here is that the intention of the legislature is to keep you married, right? So you are separated, but you are still a married couple. You're still spouses of each other. It is often referred to as divorce from bed and board. What it is trying to say is that you're not cohabiting with each other, and you are nonetheless still married. It is only and only done by an operation of the law, as in you have to go and ask to the court for the decree of judicial separation. It is not same as divorce. It is similar to divorce. In a minute, you will understand why it is similar to divorce. And we will also go ahead and compare these two things. Before I go any further, I have to tell you one very important thing. It is not part of the presentation, but listen to this carefully. So, H&W, married couple, as and when they are progressing in their marriage, they are realizing that marriage is not a union which is indissoluble, right? So when spouses come to a point where they are of the opinion that there is some kind of conflict and this conflict must be resolved, and now that resolution can vary in multiple ways. So what I'm basically trying to tell you is that spouses have what is called as remedies. There are basically two kinds of remedies. There are matrimonial remedies are divided into two parts: main remedies and ancillary remedies. Main remedies are restitution of conjugal rights, decree of judicial separation, divorce, and these are the main, and also a decree of nullity if you want to dissolve, if you want to declare your marriage as void. It was never a marriage to begin with. So there are four main remedies of matrimonial remedies, and then there are some ancillary remedies, something which is supplemental. So ancillary remedies include custody, adoption, and not adoption, custody, maintenance, and maintenance also is divided into three parts. So there is maintenance which is permanent, which is also called as alimony, maintenance which is interim, which is maintenance pendent light, and then there is maintenance which is only available to wife under the Hindu Adoption and Maintenance Act. So this is how it is divided. We are talking about matrimonial remedies here. And judicial separation is one of the primary main judicial matrimonial remedy, right? Let's move forward. Now, we are going to start off with judicial separation under Hindu law, which is Section 10 of the Hindu Marriage Act 1955. I have the Bare Act with me. If you want, you can refer to Bare Act on whatever respective devices you have, or you can just listen to me read this out. Either party to a marriage, Section 10, subsection 1, either party to a marriage. This is a remedy available to both the spouses. So this is very apparent from the section. Either party to a marriage may present a petition, for praying for a decree of judicial separation on any of the grounds specified in Section 13, subsection 1 and subsection 2. Now, begs the question that why are we giving judicial separation on grounds which are not even mentioned in Section 10? So this is why in the previous slide, it was written judicial separation versus divorce. Basically, at this point, I want you to know that the grounds on which you get divorce are same to the grounds on which you get judicial separation. So that is why the section reads that either party can present a petition praying for a decree of judicial separation on the grounds mentioned under Section 13, subsection 1 of this Act. But there are certain grounds which are only available to the wife under section 13, subsection 2. So this is what the section is reading. Now, if you're going to only refer to infer from what this means, you're not going to be able to understand, which is why judicial separation or divorce are read in consonance with each other. They are read together, right? So, whatever, so section 10, subsection 1 is saying you will get judicial separation on the grounds mentioned in section 13. That is what it is saying. Either party has the right to approach the court praying for a decree of judicial separation. Section 10, subsection 2 is saying that where a decree of judicial separation has been passed, it shall no longer be obligatory on the parties to cohabit with each other, but the court may, on the application by petition of either party and on being satisfied of the truth of the statements, rescind the decree if it considers it just and reasonable to do so. Like I told you, it is the objective of the legislature to preserve the institution of marriage. So, section 10, subsection 2 is saying that if a decree of judicial separation is passed, the parties are under no obligation to cohabit with each other. They don't have to live with each other. They are under no obligation to live with each other, hence the word separation. Secondly, if the court is of the opinion that facts and circumstances have changed in such a manner that it is imperative that this decree may be rescinded, this decree may be revoked, the court may do so, but only and only the court may do so. I hope it is clear up until this point. If you have any questions, write them down. We'll do the Q&A at the end of this class. Now, who can file a petition under Section 10? Now, given that I have told you to refer to the Bare Act, either party to a marriage. So it is available to anybody who is anyone who is a Hindu, who is married, and to whom HMA, which is Hindu Marriage Act, applies. Any spouse aggrieved can file a petition in district court under Section 10 for judicial separation. It is not required for the parties to live together. This is why I was telling you to refer to the Bare Act. Just a word of advice to everyone that irrespective of what subject you are studying, if it has a Bare Act, remember that everything that you need to know about something can come from the Bare Act. All you need to know is learn how to read it and how to infer it, right? So, like I said, section 10, subsection 1 says both the parties or either of the party can present a petition to the court praying for a decree of judicial separation on the grounds mentioned under section 13, subsection 1, and to the wife, certain more grounds under section 13, subsection 2. Section 10, subsection 2 mentions that if a decree of judicial separation has been passed, spouses don't have to cohabit or live with each other. And secondly, if the court is of the opinion that it is just and reasonable to revoke or rescind judicial separation, it can do so. That is what is section 10. Now, what are the grounds for judicial separation? For that, I need you all to refer to section 13 of the Bare Act, right? Now, section 13 of the Bare Act is saying, let us divide section 13 into few parts. That way, it is easier for us to decipher. If you know the grounds now, it will be easy for you to understand divorce also. Grounds for judicial separation and grounds for divorce are same, which is very, very important for all of you to remember at this point in time, right? Just give me 1 second. I need to see if this is mentioned ahead or we need to discuss it right now. Just give me 1 second. All right. Whatever you were going to read in the grounds for judicial separation, these are also the grounds for divorce. Now, remember, I told you that judicial separation, to present a decree of judicial separation, either party can approach the court. So first of all, we are going to read the grounds which are available to both the spouses. Then we will read the grounds which are available only and only to the wife. Remember that judicial separation, the husband and wife both have the same number of grounds on which they can ask for judicial separation. Then section 13, subsection 2 mentions that the wife has more grounds to ask for judicial separation, but there is no such thing as a mutual judicial separation. I hope it is clear to everyone. Let us start with understanding what these are. I am right now telling you conceptually what they are. When we do section 30, you will understand what these mean. So, starting off with any marriage, I am referring to section 13. If you have the Bare Act with you, wonderful. If you don't, please listen to me carefully. Any marriage solemnized, whether before or after the commencement of this act, we are not going to pay attention to all of this right now. All we need to figure out is what are these grounds. So, starting off with, uh, on petition presented by either the husband or the wife, be dissolved by a decree of divorce on the ground that number one, 13(1), Roman numeral 1, has had voluntary sexual intercourse with any person other than his or her spouse, which is, to easy way to remember that is adultery. First ground, adultery. Meaning thereby, either party can present a petition for judicial separation if their spouse has had voluntary sexual intercourse with somebody who is not their spouse. Now, let us take the same example. H and W, two Hindus married under the Hindu Marriage Act. If the wife has had voluntary sexual intercourse with, let's say, A, right? A is not her spouse. This is a voluntary sexual intercourse. What she has done is adultery. The act is adultery. The husband can present a petition for judicial separation. So you will not find these words as they're written here in the Bare Act, but please read it from the Bare Act so that you know what they actually mean. So, first ground of for asking for judicial separation is your spouse has been adulterous or they have committed adultery, having voluntary sexual intercourse with somebody who is not your spouse. Ground one. This is section 13(1), Roman numeral 1. I hope it is clear to everybody. Now we come to the second part, 1A. Has after the solemnization of marriage treated the petitioner with cruelty. Now, cruelty is as is mentioned. I will discuss cases as well for you to understand it better. Cruelty is not defined and it is deliberately not defined. Sometimes, when there are words which do not have a very specific meaning or very specific definition in the Bare Act, it is intentional so that definitions could be exhaustive and they could mean a lot of things rather than them being restrictive and mean only a few set of things. So cruelty is not defined, but cruelty has been defined by judiciary, has been interpreted by judiciary in multiple cases, as we will discuss ahead. Right? Now, ground number 3 is has deserted the petitioner for a continuous period of not less than 2 years. This is number 3. So, adultery, cruelty. Number 3 is desertion. Now, is desertion means having to, without any reasonable cause, withdraw from the society of the spouse, and uh, it must be continuous for a period of 2 years. So this is what is desertion. I'll explain to you desertion in a minute ahead. Next is has ceased to be a Hindu. Conversion. Now, if we are talking about the Hindu Marriage Act and the provisions of Hindu Marriage Act will stop applying to you if you are not a Hindu. So, if you are somebody to whom HMA applies, if you stop being a Hindu, that is a ground available to your spouse to ask for a divorce. So, conversion is another ground for asking for judicial separation as well as divorce. Then has been incurably of unsound mind, or there is a mental disorder. Now, this has been very clearly defined as to what exactly is mental disorder or a psychopathic disorder. So if either of the spouse is suffering from any kind of mental disorder or insanity, which is making it difficult to subsist the marriage and continue in the marriage, the spouse has an option to either approach the court for a judicial separation or to approach the court for a divorce, because this is a ground for a divorce as well. Next is has been suffering. This is conversion, unsoundness of mind, leprosy. Leprosy now has been removed as a ground as of 2019 because earlier leprosy was considered to be an incurable disease. Now it is clearly mentioned here that has been suffering from a virulent and incurable form of leprosy. Virulent means it is very advanced, it is very all right. We were discussing leprosy as not being a ground for divorce. I'm sorry, the light went off here for a minute. I hope I am audible and visible to everyone. So, important thing to note here that venereal disease is any disease which is incurable and which is communicable. Leprosy used to be an incurable disease, but as of 2019, it has been removed as a ground for asking for judicial separation or divorce. All right. So that is another ground. Next is has renounced the world by entering into any religious order. So religious order doesn't necessarily mean that you've garbed yourself in clothes that resemble that of a hermit. But no, you've renounced the world as in you've left all worldly possessions. You've uh, come to a point where there is no marital obligation as well as no marital relations that can subsist after you entering into a religious order. So this is a renunciation of the world in its, and you have to undergo a whole process and have to undergo a ceremony of renouncing the world. Only then will it be considered a renunciation. Renunciation by joining a religious order, right? And lastly is you haven't been heard alive for a period of 7 years, meaning thereby that for a period of 7 years, you were not found to be alive. There is absolutely no trace of you. So it will be presumed that you are dead. This wraps up the grounds that are available to both the husband and the wife to ask for judicial separation, which is given under section 13, subsection 1, to give it a roundabout to all of you. So, what are the grounds for judicial separation available to both the spouses? Adultery, cruelty, desertion, mental disorder, unsoundness of mind, renouncing the world, conversion, and presumed dead. Presumed dead. So these are the grounds which are available to both the husband and the wife. These grounds are mentioned under section 13, subsection 1. They are similar to divorce as well as applicable to judicial separation. Now I'm going to go through cases so that it is easier for everyone to understand what do these things actually mean. So it can Subarama Reddyar versus Sakaswati Amal. So in this case, spouses successfully prove the presence of the adulterous relationship of their partner, and then only the party can approach the court. Now it is very clear if you are alleging that your spouse is adulterous, it is you who has the burden of proof to prove that the spouse is adulterous. So this is what this is mentioning. Next is cruelty. Now, very landmark judgment of cruelty is Dastane versus Dastane. Here it is Manisha Tyagi versus Deepak Kumar, also a case mentioned. I will tell you about Dastane versus Dastane because it is a landmark judgment to understand what exactly is cruelty. Now, what happens is that, actually, wait, I have to discuss something more in adultery first. So we all know, and I hope that all of you know, that as of 2017, I may be wrong, since the case of Joseph Shine versus Union of India, adultery as an offense has been removed from IPC. It is still a ground for divorce, it is still a ground for judicial separation, but it is not a penalized offense anymore. I also want to explain to you that what exactly does adultery meant in that section. Why was that section declared unconstitutional? That section was from IPC. It was declared unconstitutional because it was, the section meant that if the husband finds out that the wife is having voluntary sexual intercourse with another man, he can file a case against that man, not against his wife. And that man will then go to jail because he was having voluntary sexual intercourse with a wife of somebody else. If you read the provision, it reads, if a man has voluntary sexual intercourse with a wife of someone else. This is what adultery in IPC meant, which was uh, which was a gender bias because this specific section did not penalize voluntary sexual intercourse by a man to with another woman if he's married and he's cheating with another woman. And secondly, women were not penalized for adultery. So this is why adultery as a criminalized offense, as a penal offense was removed. It is still a ground for husband as well as wife to ask for divorce. So I wanted to clarify this to everyone that Joseph Shine versus Union of India is a landmark judgment which said that which decriminalized adultery as an offense and declared Section 497 of IPC as unconstitutional. But you must know that this adultery and that adultery are not the same. I hope it is clear to everyone. Moving on, cruelty. I was talking about Dastane versus Dastane. So what exactly does cruelty mean? Dastane versus Dastane is a wonderful case to understand what had happened, what happens, and what exactly is cruelty. So all of us know that if you are hitting somebody, if you are physically hurting somebody, that is cruelty, that is physical torture, very apparent. But then there is also something as mental cruelty. Now, in Dasane versus Dasane, what happened was husband and wife, both of them were doctors. And the husband found out that wife was suffering from some kind of mental disorders, like not exactly disorders, but she was taking medication and she would behave in such a manner where it was considered that she was taunting him, she was gaslighting him, she was making it very difficult for him, she was manipulating him. Now, the problem with all of this is that how will you decide what kind of conduct is mental cruelty? So this case said that it will be considered as mental cruelty if a person is making it difficult for the other spouse to live with each other, to make it difficult to cohabit with each other. But you can only approach the court asking for judicial separation or divorce on the ground of cruelty if you have not condoned the cruelty for a long period of time. Now, question arises, what is condoning? Condoning means accepting it. So in this case, the husband asked the court for divorce under this section key, cruelty. The court said that, and the wife filed a countersuit against the husband for cruelty. The court said that you cannot approach the court by pointing out that it is a problem that you have just realized. Now, the thing is, let's say two people are married, H and W are married, and H, the husband, finds out over the course of marriage that the wife is somebody who's a violent person by nature. So she is in the habit of breaking property, destroying property, and sometimes she gets very violent and she also exhumes physical violence. Now, started to find out this behavior 2 years after the marriage. And he thought that maybe after a while it will be fine. She will stop doing this. 10 years go by. 10 years later, he comes to the court and says that she has been doing this for 10 years. This is cruelty. I want divorce. The court will say, you have been condoning the act of cruelty, meaning tolerating it. You have been okay with it. You have been slipping it under the rug. Now you cannot approach the court saying that this is cruelty. Meaning thereby that if you are asking divorce or judicial separation on the ground of cruelty, you must be you must not condone the act. If earlier you were okay with it, then now you are not okay with it after a long period of time. This is a very basic requirement to establish cruelty. So Dastane versus Dastane is a very landmark judgment. I will read Manisha Tyagi versus Deepak Kumar also. The wife was accused of cruelty by the husband, and to which divorce was granted by the district court and the high court. But it was challenged in the Supreme Court, and the court mentioned that there was a lack of evidence on proving the parties, providing the parties judicial separation to contemplate the status of their marriage. Now, just give me 1 second. Like I said, that the court, judiciary, and the legislature, they want to preserve marriage. So judicial separation is the only remedy which can be given even if the parties are asking for a divorce. It is a unique remedy which is an alternative remedy which is given by the court. It is mandatory that whenever the parties are approaching to the court asking for a divorce, they have to undergo a period of mandatory 1 year of judicial separation. So basically, the court wants you to rethink your divorce before actually giving you a decree of divorce. But this comes with the exception that in some cases, the grounds for divorce and the facts and circumstances are such or of such a manner that it is absolutely imperative that a divorce should be given. But ideally, what the court does is whenever a couple approaches the court asking for divorce, the court gives them judicial separation. That you go and you contemplate it. You are still spouses, but we are giving you the right to be separated from each other. Think about it. If within this 1 year you are not able to reconcile and you cannot cohabit with each other, then we will award you the decree of divorce. So this is a unique thing about judicial separation. Now, conversion, like I said, HMA applies to Hindus. Application of the act mentions who is a Hindu, Hindu by birth, Hindu by religion. So if you cease to be a Hindu, this act stops applying on you, number one. It also gives a right to your spouse who is also a Hindu to ask for a divorce. If any party converts their religion from Hindu to any other religion, the aggrieved party can file a petition for judicial separation. In the case of Madan Sita Ramalu versus Madan Vimla, the wife had converted into Christianity. The court granted judicial separation and then later on granted divorce to the husband. Unsoundness of mind. Anima Roy versus Prabhat Mohan Ray explained that unsoundness of mind is not traced around the time of marriage, then the court cannot grant judicial separation to the parties. How will you find out unsoundness of marriage? Let's say H and W get married. After that, W gets into an accident, goes insane later on. Can the husband ask for a divorce? No. Unsoundness of mind must be determined at the time of marriage. That when you were marrying, you found out that there is unsoundness of mind. Or you have later discovered that at the time of marriage, they were of unsound mind. You just did not know of it. So it's like that. Leprosy, like I told you, leprosy is no more a ground to ask judicial separation or divorce because it is curable. Venereal disease, it usually includes any kind of STD like HIV and AIDS. If you are in a position to infect the other party, the aggrieved party has the option to approach the court for judicial separation followed by divorce. Now, this is section 13, subsection 1, which gives 9 grounds of divorce to both, 9 grounds of divorce and judicial separation to both husband and wife. Now we come to a point where there are certain grounds which are specifically available only to the wife, which are mentioned under section 13(12). 13, subsection 2. Now, what is 13(2) reading? 13(2) starts off with, a wife may also present a petition. A wife may also present the petition, meaning only ground available to wife. On what ground? Starting off with, husband has remarried again. Just underline important words from the Bare Act, or listen to me while I read you from the Bare Act. Husband has married again, meaning thereby bigamy. Bigamy immediately makes the marriage bigamy is, if you do bigamy, according to section 5 of HMA, the second marriage is void ab initio. And your wife, existing wife, gets a right to ask for judicial separation or divorce. So, has married again. Well, the spouse was already alive, had a spouse living at the time. This is the word of the Bare Act. Next is, the husband is guilty of rape, sodomy, or bestiality. If the husband has been found guilty of these 3 offenses of rape, sodomy, and bestiality, then wife has a right to ask for judicial separation or divorce. Next is Section 18 of the Hindu Adoption and Maintenance Act is giving a right to the wife to ask for maintenance. I will read you section 18. Section 18, the heading is maintenance of wife. It is only and only section which mentions maintenance to the wife only, right? So this is very, very important to note down. Lastly, if a wife was married when she was under the age of 15 years, after she has turned 18, after attaining the age of 18, she can file for judicial separation. This is also a ground only and only specifically available to wife. And even then, there is a statute of limitations that, let's say H and W got married. W was 12 years of age when she got married. When she turned 18, she wants to file for judicial separation or divorce. She has to do that after 3 years after attaining majority. After that, statute of limitation expires. This PPT doesn't mention 13(2)(3), which I was reading earlier. So these are grounds which are specifically available to the wife. I want to discuss a couple of other cases of judicial separation with all of you. And rather what happens after judicial separation. The status of the parties is that they are still married. Like I told you, judicial separation is step 1. If you are going for a divorce, judicial separation is step 1. So parties ultimately are still married. They're legally married, and they are not, they're still spouses of each other. Narasimha Reddy versus M. Busamma, very landmark judgment. Court, after passing the decree of judicial separation, gives a gap of 1 year to the parties, to which they can contemplate whether they want to resume their relationship or do they want to reconcile or not. During the separation, the party is in no sense moved out of the line from the inheritance of property, as they are lawfully still spouses. Because you are still spouse, your rights and duties and obligations in terms of inheritance and succession are still going to be in place. The whole point of marriage as an institution is that a lot of civil liberties also flow from marriage, such as the legitimacy of children, such as inheritance and succession and writing away or giving away your property in by testamentary disposition, which is like making a will. So nothing will change just because you are judicially separated, because technically you're still spouses. If the court is of the view that the wife is unable to sustain herself during judicial separation, then maintenance to fulfill her basic needs shall be given, which is why I come to section 24 of the Hindu Marriage Act, which is maintenance pendent like. Pendent like means interim maintenance during the pendency of proceeding. What proceeding? Proceeding from section 9 to section 13. Restitution of conjugal rights, judicial separation, decree of nullity, void or voidable marriage, or divorce. If a spouse, if two spouses are undergoing any proceeding which falls under the categories of section 9 to 13 of Hindu Marriage Act, under section 24, either party has a right to get maintenance from the other party if they are not able to maintain themselves. Maintain themselves how? Two things are important. First is the expense of the proceeding, entire expense of the proceeding. And secondly, during that time, they need intervals or monthly intervals or monthly payments to take care of themselves. This is what this case is also talking about. Gomathi versus Kamara Gurupan held that after the passing of decree of judicial separation, the parties do not resume to court, then they can move to the court. Okay. If after 1 year, parties do not resume cohabitation, they can move forward with divorce. So if you are going for divorce, step one is you will have to be first be judicially separate. Now, Muslim marriage does not talk about judicial separation, or Muslim personal laws don't talk about judicial separation at all. I will tell this to you in a slide ahead also. But because we are discussing judicial separation, let us also study it from in the Parsi Marriage and Divorce Act of 1936. So it is mentioned under section 34. Any married person may sue for judicial separation on any of the grounds for which one person could have filed a divorce. Now, if you read this, it is very clear. Grounds for divorce, ground for judicial separation are the same. In the Parsi religion, marriage is viewed as a contract and is celebrated through a ceremony known as Ashirvad, during which a priest bestows blessings upon the married couple in the presence of two Parsi witnesses. Under this act, specific provisions were established to address the issues like annulment of marriage, divorce, and judicial separation. These grounds, which are mentioned under section 34, are very similar to the grounds which are mentioned under section 32. Ground for divorce is same as ground for judicial separation. And they resemble, this is a very important line mentioned here, these grounds resemble those found in the Special Marriage Act as well as the Hindu Marriage Act. Now, like I told you, Muslim law does not recognize or does not give a provision for judicial separation. As stated in the case of Rahmatullah and Khatun Nisa versus State of UP, Muslim personal law or the Shariat law recognizes talaq, but it does not recognize judicial separation. It is only found in Hindu Marriage Act, Special Marriage Act, and also in Parsi Marriage Act. While there is no specific law allowing for judicial separation in Muslim marriages, there are certain landmark cases that have extended the grounds mentioned in Section 2 of the Dissolution of Muslim Marriage Act to which can lead to dissolution of marriage. So, Section 2 of the Dissolution of Muslim Marriage Act can be considered as a judicial divorce. So, when I tell you divorce in Muslim law, it will be clearer. But divorce in Muslim law is a very multifaceted transaction. It's a very multifaceted procedure. But it is divided into basically two parts. It's a judicial divorce or it is an extrajudicial divorce. Under the judicial divorce is section 2 of section 2 of Dissolution of Muslim Marriage Act, which mentions certain grounds which are available to the wife to ask for a divorce. So they look like there are more grounds available to the wife. So the husband's whereabout is being unknown for 4 years, so that is desertion. Neglect or failure to provide maintenance for 2 years. Husband is sentenced for a cognizable offense because he's punished for and punished and imprisoned for a period of 7 years or more, failure to fulfill marital obligation for 3 years, impotency. Now some of these grounds are also grounds in Hindu Marriage Act to ask for a decree of nullity instead of a judicial separation or divorce. Insanity, leprosy, venereal disease, repudiation of marriage, like I told you earlier, and cruelty. These are very similar. In this case, the court judges outlined various grounds under which a Muslim wife can seek a divorce for the dissolution of her marriage. Case also emphasized the need for uniform laws. Now we'll come to that at the end of this session as to why do we need UCC. Now let us start with provisions related to divorce. Now, Hindu Marriage Act talks about it. Muslim Personal Law Shariat Act talks about it. Muslim Dissolution of Marriage Act talks about it. Indian Christian Marriage Act talks about it. Divorce Act of 1869 and SMA, which is Special Marriage Act, talks about it as well. Now, we're going to start off, I think, if I'm not wrong, with Hindu personal laws. Now, given that I already told you Section 13(1) and Section 13(2), you already know what are the grounds which are available to both the spouses and grounds available only to the wife in terms of asking for a divorce, because they're same. So what is written here, you all can tell me yourself. Has voluntary sexual intercourse with any other person, adultery. This is 13(1). Partner has treated the applicant with cruelty, desertion, conversion, mental disorder, communicable form of venereal disease, such as an STD, renunciation of the world, hasn't been heard, presumed dead for 7 years or more. Everything is very similar to what I just told you for judicial separation. This is where it is actually mentioned. It is only imperative that I now tell you that divorce under Hindu law is also studied conceptually, because before the commencement of the Hindu Marriage Act, divorce was, and actually to this date, divorce is a taboo. It is something which is very embarrassing and it destroys people's reputation. When Hindu Marriage Act was enacted, it told, this law explicitly told people that marriage is not a sacrament. Marriage is not it is a union of man and women, but it is not a union which can never be dissolved, because it gave grounds for divorce. So it is only imperative that when this act was passed, how a marriage is breaking down was also studied conceptually. So given the different kinds of different modes of divorce, there are various theories of divorce as well. Starting off with breakdown theory of divorce. Breakdown theory of divorce is when the couple has been living apart from each other for more than 1 year after the judicially separated. When the court has passed a decree of restitution of conjugal rights and spouses have to cohabit with each other, but there is no resumption of cohabitation after 1 year of passing the decree. And when the husband is bigamous, husband is guilty of rape, bestiality, or sodomy, he has not given maintenance to the wife. When all of these things are happening, the marriage has broken down. It is also called as an irretrievable breakdown of marriage. Irretrievable meaning that you cannot resume, you cannot try to reconcile. So the grounds mentioned, some of them qualify as an irretrievable breakdown of marriage. Section 13(b), which I did not talk about, is talking of judicial, is talking about divorce by mutual consent. Now, there is a fault theory, there is an irretrievable breakdown theory, and then there is a mutual consent theory. Earlier, there used to be a disease theory when you have communicable disease, leprosy, mental disorder. But now leprosy has been removed from that. So there are basically three theories of divorce, actually four in some books. First is irretrievable breakdown. Your spouse has done, you and your spouse are not able to come to a point where you can start to live with each other. So that is also when you have mutually decided that it is in the best interest of both the parties that they get divorced. Next is fault theory. When your spouse has done something wrong, adultery, cruelty, desertion, conversion, renunciation, presumed dead, all of these are fault theory of divorce. Whereas fault, irretrievable breakdown, disease, yeah. Irretrievable breakdown of marriage can also be coupled with mutual consent, because you both have come to this opinion, you have mutually decided that it is in the best interest that we do not continue in this marriage. Now I come to grounds for divorce in Muslim law. But before going into grounds for divorce under Muslim law, I want to tell you about divorce under Muslim law. So we are going to divide the entire portion of divorce into four parts. I hope you all have any form of note making available to you so that you can write down whatever I'm going to tell you. Just give me 1 second. All right. I wanted to discuss divorce by mutual consent in a little bit more detail before I go ahead with divorce in Muslim law. So, divorce under Hindu law, like I told you, that it was alien to even entertain. That Manu was expressly against the concept of marriage, and hence stated that the union, against the concept of not marriage, divorce, and hence stated that the union of husband and wife should be continued till death. Not only this, it even stated that duty of the wife does not even end after the death of her husband. She's not allowed to have a second husband. It is things like these that gave sanction to practices like sati, that if a husband has passed away, the obligation of the wife has not ended and she must also die. So it is very, very apparent that we talk about divorce by mutual consent in a little bit more detail. So it is very, very similar in the way that it is the consent of both the parties without any kind of disqualification, that they have decided within themselves that it is in the best interest of both the parties, that and it is in the interest of everyone else that they mutually have agreed to dissolve the marriage. I will read you this subsection. Just give me 1 second. Subject to the provisions of this act, a petition for dissolution of marriage by a decree of divorce may be presented by both the parties of the marriage together. This is unique because it is written by both the parties to a marriage together, on the ground that they have been living separately for a period of more than 1 year, they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. Very clearly, Section 13, subsection B, mentions divorce by mutual consent. Both the parties approach the court together, saying that we have been separated, we have not been able to live with each other for 1 year or more. It is in the best interest that we dissolve this marriage. So this is what Section 13B is talking about. parties have not been able to live with each other. Here is a case which is mentioned, Sureshta Devi versus Om Prakash, wherein it was made clear that living separately does not necessarily mean living in different places. One more thing that I want to tell you is that in India and in most Hindu marriages, the wives are dependent on the husband, right? So it is separate housing. So when even after obtaining a decree of judicial separation, people can continue to live in the same dwelling house. So living together but not as spouses is what is important, that they are living together in the same house but they're not living as spouses. Sadly enough, it often happens that the parties are not able to live together even after trying mediation and reconciliation and putting multiple efforts before filing for divorce. In Pradeep Pant and another versus Government of NCT Delhi, the parties were married and had a daughter from their wedlock. However, due to temperamental differences between them, they were not able to live together and decided to live separately. Despite putting their best efforts, they were unable to reconcile their marriage and could not see themselves living together as husband and wife ever again. A divorce petition was jointly filed, and issues such as maintenance and custody were decided and agreed upon by both. The wife would get the custody of their daughter, husband would get visitation right. It was mutually agreed upon by both of them. Now, this is a very beautiful example to explain what is judicial separate, which is what is divorce by mutual consent. So this is a very landmark judgment. Now, how do you actually get a divorce by mutual consent? First is jointly filing a petition. Like I told you, this is unique because mutually agreed by both the parties to a marriage, clearly mentioned in the Bare Act. Divorce petition in the form of an affidavit is signed by both the parties and filed before a family court in their region. Court jurisdiction shouldn't be a major issue for filing for divorce, as it must be within the ordinarily permissible civil jurisdiction. The parties to a marriage must be living separately for a period of 1 year before filing for the petition for divorce. First motion. After filing the petition, the parties shall appear before the court and give statements. If the court is satisfied that the statements are recorded, and so basically, let me tell you this in a short manner so that it is easy for you to digest it. Basically, 3 times the court calls you. There are 3 sittings. So after the first is where you petition. Then court asks you to go and think about it. We'll meet again. And then the court will call you again and then ask, are you not reconciling? Are you not reconciling? In cases of divorce, it is mandatory, especially in the Family Court Act, Section 9. You can check if I have it with me. I can check it as well. Just give me 1 second. Yes, Section 9 of the Family Court Act reads that it is duty of the family court to make efforts for settlement. And it is absolutely mandatory for the family court to push and to sort of encourage the parties to undergo mediation as a way of reconciling their differences, right? So this happens step by step. Second motion, okay. The 6-month waiting period mandatory for getting a divorce by mutual consent. When you go and ask for a divorce by mutual consent, the court asks you to go and live with each other for 6 months to contemplate whether you want to continue with the divorce or not. Now, in Amardeep Singh versus Harveen Kaur, it was observed that the couple had internal disputes and their married life was not the best one. Disputes escalated really badly and many civil and criminal proceedings were also happening. They mutually decided to resolve all their disputes and file for divorce by mutual consent. Parties could no longer live with each other. Honorable Supreme Court laid down that the waiting period of 6 months can be waived off. Very important, can be waived off if the court is satisfied that if you're not able to live with each other for more than 1 year, what is the point of forcing you to live with each other for 6 more months? It's very simple like that. So it is best to waive off the 6-month period if somebody is approaching the court and asking for divorce by mutual consent. K. Om Prakash versus K. Nalini, parties were not happy in their marriage and were allegedly having extramarital relationships. It was the contention of the petitioner that they were living apart and were even visiting each other, but they were not even visiting each other for more than a year. So there was no scope of reconciliation. The marriage had suffered irretrievable damage and they had reached a point of no return. Sorry. The Andhra Pradesh High Court held that Hindu Marriage Act, Section 13B, should be read not as a statutory mandate, but only as a directory, which means that waiting period, which was once mandatory in nature, is now a discretion of the court. If the court is of the opinion that if you're not able to live with each other and you have not been able to live with each other for a period of 1 year, there is no point of prolonging the suffering of two people and forcing them to live with each other for 6 more months. It's very basic like that. Whether consent can be unilaterally withdrawn for divorce by mutual consent. Now, the wife, Sureshta Devi versus Om Prakash, the wife consent was fraudulently obtained by husband filing for divorce, and the wife was unwilling to give consent, and she did a unilateral revocation of consent. The Supreme Court said that a party can unilaterally withdraw their consent if the same has not been freely given. We don't talk a lot about consent when it comes to marriage, but we talk about consent when we are dissolving the marriage, because ultimately it is the objective of the legislature as well as the judiciary to preserve the institution of marriage. Rajat Gupta versus Rupali Gupta. Court says that agreement between the parties to settle their issues and opt for divorce by mutual consent is a binding agreement and a form of undertaking. If a party now unilaterally withdraws their consent, there would be a breach of their undertaking, resulting in the civil contempt of the court. Therefore, consent can be unilaterally withdrawn only and only in exceptional cases on reasonable grounds. Now, this is a tabular comparison of difference between judicial separation and divorce. I think you are in a better position to be able to understand it yourself. I will now go back to Muslim marriage, or rather Muslim personal law and talaq. Now, talaq, before talaq, I must also tell you nikah. Nikah is a union of man and woman who are both Muslims. The purpose of nikah is that it is to add generations to the society, to legitimize consummation of marriage, to legitimize children, and to stop any kind of unchastity, foulness, and bastardization. So, Muslim personal law takes their marriage institution as very, very sacred. Although we are of the opinion that Muslim marriage is a contract. Mullah, who is a scholar who has written extensively on personal law, especially on Muslim personal laws, he says that Muslim marriage is a contract. But that is because it resembles a contract. So today I want to tell you that don't call it a contract. Call it a procedure. Call it a transaction. Why? There is an offer, which is ijab. There is an acceptance, which is kabul. There is dower, which can be considered as consideration. And there are witnesses who must be present for a nikah to be completed. Nikah doesn't happen. Nikah is read. मतलब शादी होती है, निकाह पढ़ा जाता है, निकाह is read. So you must understand the technicalities and the ethos of the religion to understand why things are in the way that they are. So without further ado, talaq. Now, talaq under Muslim personal law is divided into 4 categories. What are the 4 categories? I hope you all have with you some notes so that you can listen to what I am saying. First and foremost, marriage, talaq can be of 2 kinds. I'm going to make multiple uh, bifurcations. To please bear with me. Starting off with, talaq is of two kinds. Broad categorization, revocable and irrevocable. Revocable divorce is talaq-e-rajai, meaning that before it becomes final, parties can take it back. Talaq-e-bain is when the talaq is irrevocable. Once done, complete. Marriage is dissolved. So we don't study divorce under Muslim law. We call it dissolution of marriage under Muslim law, which happens in two manners. If the party dies by death or by divorce. For Hindu law, divorce is putting an end to the marriage. Divorce means you were spouses, now you're not spouses. In Muslim personal law, divorce is a way in which you dissolve marriage. There is a difference in terminology, right? So, first and foremost, two kinds of talaq. Talaq-e-rajai and talaq-e-bain. Talaq-e-rajai is revocable divorce. Talaq-e-bain is irrevocable divorce. Moving forward, who can pronounce a divorce? What is the competency of the parties to a divorce? So the competency is any Muslim male, please listen to this very carefully. Any Muslim male who is of sound mind, who has attained the age of puberty, not majority, puberty. Muslim male, sound mind, has attained the age of puberty, can give divorce to the wife at any time without any cause. That is the bedrock of talaq under Muslim law. Bedrock, basic. Two kinds of divorce, revocable, irrevocable. Competency by the husband to the wife. Husband must be any Mohammedan male, sound mind, age of puberty, can give divorce to the wife without any reasonable cause at any time. Now, let us take this one step further. How do you give divorce? Two kinds. Oral, you can pronounce divorce. Written, when it is reduced in the writing, it is called talaq nama, right? Now, we come to further bifurcations. Divorce happens by different methods. Method one, by the husband to the wife at the husband's will, by the husband's will. This is step one. Step two, by the wife to the husband, but the wife is getting a power which the husband is delegating to her, or the husband is delegating the power of divorce to a third person. Number two. Number three is divorce by mutual consent. They also have divorce by mutual consent. And number four is by a operation of law or judicial decree, which is section 2 of Dissolution of Muslim Marriage Act. So this is the broad categorization. Now let us take it one step further. Which was the first kind of divorce? By the husband to the wife at the husband's will. This is called talaq ul sunnat. This is called talaq ul sunnat. First kind of divorce. Now, by the husband to the wife at the will of the husband happens in four manners. We started off with revocable and irrevocable. Then we talked about who is competent to give divorce. Now I'm talking about four ways in which divorce happens. By the husband to the wife, by the wife to the husband, because he delegated the power of divorce to her or a third person, divorce by mutual consent, divorce by judicial decree. Now, by the husband to the wife has four bifurcations. Number one is talaqul sunnat. Number two is talaqul biddat. Number three is ila. Number four is zihar. I hope you're all able to follow this. Now, talaqul sunnat is divided into two parts. Ahsan and Hasan. Ahsan and Hasan are two kinds of talaq ul sunnat. I hope you are all able to follow this. Everything is written here. After you listen to what I'm saying, you can read it. It will all make sense. Now, talaq ul sunnat. Now, sunnat is a ancient source of Muslim law. So this is considered as the best way of divorcing. Talaq ul sunnat. Ahsan and Hasan. Ahsan is considered to be the best form of divorce. Hasan is considered to be an okay form of divorce. It's a good form of divorce. So what happens in talaq ul sunnat, or rather what happens in Ahsan and Hasan is, I'm starting off with Ahsan, which is best, is that the husband makes a single pronouncement. He says, I am divorcing you. He does this during the period of Tuhar, Tuhr. Tuhar is the time period when the wife is not menstruating, when the wife is not undergoing menstruation. She's not on her periods. When the husband says one single pronouncement, I am divorcing you, single pronouncement during the time when she is not having her period. From that single pronouncement, iddat period begins. Iddat is a period of 90 days that a woman who has been divorced has to observe mandatorily, right? So he says that, and 90 days later, the divorce by husband who said that I am going to divorce you, he said that, wait, in that period 90 days, after the expiry of 90 days, divorce becomes irrevocable. So from talaqul sunnat, ahsan, it becomes talaqe bain. It becomes. Now, this 90 days period is given as a buffer to the parties if they want to reconcile, if they want to go through mediation or arbitration. But after the expiry of 90 days, the divorce becomes irrevocable. I hope it is clear to everybody. Next is talaq hasan. It is similar to hasan, but in this case, you have to make three pronouncement in three tuhars. So technically, that period is 90 days only. Single pronouncement, iddat period begins. 30 days later, second pronouncement. 30 days later, third pronouncement. After the third pronouncement, divorce becomes irrevocable. So, talaqul sunnat, ahsan, best, hasan, okay. 90 days iddat period. During this iddat period, husband and wife cannot engage into sexual intercourse. Complete abstinence. Complete abstinence. This is the first kind of divorce. Talaq ul sunnat, by the husband to the wife. Now we come to talaq ul biddat, by the husband to the wife. Talaq ul biddat is also commonly known as triple talaq. We all know about triple talaq. We also know about Shaira Bano versus Union of India 2017, which criminalizes the practice of triple talaq and which declared triple talaq unconstitutional. So basically, talaq ul biddat is instant divorce, instant irrevocable divorce. Husband says, I am divorcing you, done, dusted. Divorce has happened, irrevocable. This is unconstitutional. And now, after Shaira Bano's case, it is criminal offense also. If a husband says uh, that he's divorcing his wife and it is triple talaq, it is a single pronouncement of instant divorce, he will be sent to jail for 3 years. 3 years imprisonment plus fine. That is talaqul biddat. Doesn't exist. It has been banned in most of the countries. In India, only the Sunni community was following it. Next is ila. Ila is a constructive divorce. Constructive divorce meaning that the husband has taken a vow, a pran, a kasam, a tapasya of sorts, that for a period of 4 months, he will abstain from his wife. He will not engage in any kind of sexual intercourse with wife. After the expiry of 4 months, the wife can go to the court and ask for the divorce. This is a constructive divorce. Talaq, this is by the husband to the wife. When the husband says, I am abstaining from you for 4 months, the wife then waits for 4 months, then goes to the court and asks for divorce. Ila. Next is zihar. Zihar is an incomplete divorce. It's called an inchoate divorce. Basically, what happens is that the husband compares the wife to any relation to which he cannot marry. For example, The husband compares the wife to the mother, and the husband compares the wife to the sister. If he is comparing the wife to a prohibited degree of relationship, whom he cannot marry, it is considered as a divorce. So, Talaqul Sunnat has Ahsan and Hasan. Then is Talaqul Biddat, which is triple talaq. Then is Ila. Then there is Zihar. These are four kinds of divorce, which is by the husband to the wife. Now we come to second kind of divorce. By the wife to the husband, but it is coming from a power delegated by the husband to the wife. And the husband can delegate this power to a third person also. It is very ludicrous, but it is how it is. Now, what happens is, let's take an example. Two people, two Muslims, male and female, get married. The husband, now a Muslim male is allowed a restricted polygamy. He can marry 4 times, restricted polygamy. So they both got married. Husband says to wife that if I marry a second time, I am giving you the power to give me divorce. He is delegating his power of divorce to the wife. So if the husband marries a second time, the wife gets the power to give divorce. In the eyes of the law, this divorce is considered as that husband only has given divorce in the eyes of the law. But it is operated in such a manner that it is the wife who is giving the divorce, but she is getting the power from the husband. Now, this power the husband can give to the third person also. Any person, if you read this, a husband can delegate the power of talaq to any person or even his wife to pronounce divorce in the same form. This is called talaq-e-tafweed. You'll find different spellings in different places. So this is also a kind of divorce where the husband is giving the power to divorce to the wife. I hope it is clear to everyone. So there we did talaqul sunnat, biddat, ila, zihar. This is husband to wife. Wife to husband is talaq-e tafweed, and or third person to husband. Next is divorce by mutual consent. That has two things, khula and mubarat. Now, khula and mubarat are almost identical. In khula, the wife offers the husband, there is an offer of divorce, there is an acceptance by the husband, and wife also gives some consideration. And then it is considered as they have divorced each other. In mubarat, the offer can come from either party. The offer can come from either party, but there is no consideration. So this is considered as a divorce by mutual consent. And lastly is divorce by way of getting a judicial decree from Section 2 of the Dissolution of Muslim Marriage Act. Now, this is entirely what is the whole point of this entire discussion. I want to sort of wrap it up in a manner that we have a little bit of discussion over why do we need UCC. Now, there is multiplicity of personal laws in our country because there is multiplicity of religions in our country, right? Which is why it is absolutely imperative that this multiplicity of laws is not misused, right? Because I am aware, if you're not aware, let me make you aware that people were converting their religion to take benefit of multiple marriages. So people were converting their religion from different religions to the Muslim religion because they are permitted a restricted polygamy, right? So Sarla Mudgal versus Union of India, as well as Lily Thomas versus Union of India, are two landmark judgments that say that you cannot change your religion just to marry again. We need UCC because if, like I abhi told you about talaq under Muslim law, it sounds like it is very patriarchal and it is favoring the husband over the wife because that is how it is written. If we have one uniform law, then there will not be disparity on the basis of religion. Although India is a diverse country, And India is a country that is practicing multiple religions. And that is why deliberately personal laws are not put under the purview of law under Article 13 of the Constitution. Narasa Appumalli versus state of Maharashtra, state I might be, or maybe state of Tamil Nadu, but Narasa Appumalli, I'm fine. Like I remember that. I don't remember the state. You can Google it yourself. It's a case which says that Article 13, which talks about laws in force, what exactly falls under the purview of law. Personal laws don't fall under the purview of law because it is the opinion of the judiciary as well as the constitution itself that there is no place of constitutional law in the matrimonial affairs of a house. There is no place of constitution in a marriage. So deliberately, personal laws do not fall under the ambit of Article 13. So with that, I am ending my side of the presentation. I'm opening the floor for questions now. You can write it in the chat and I will address all of your questions uh, as that. Or if you're allowed to, you can unmute yourself and we can discuss it. I'm going to go through the chat right now. Any time limit to file divorce petition? 1 year minimum. For cruelty, also 1 year minimum. Under mutual divorce, is it mandatory to live separately before filing? Yes, 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 yes. Mentioned under section 13(2)(b). If one spouse files for divorce, but other doesn't want it because being divorced is a taboo. Well, it is the job of the court to balance the rights and interests of both the parties. If one party wants the divorce and the other party doesn't want the divorce, this is exactly why you are sent to mediation, to different alternate dispute mechanism. But if one party wants it, and there is reasonable ground to award the decree, the court will. Partner is living with other married person, can criminal case be filed for adultery? Criminal case, no. Cruelty, adultery is not an offense anymore. You can ask for judicial separation, you can ask for divorce. It is not a ground, it is not a penalized offense. What about Article 21? Article 21, sir, right to life and personal liberty. I would like to tell you that you have this right against the state. If you make all the reason we have Article 12 and then Article 13 is first we tell you state and then we tell you what are the laws that fall under the purview of, the what exactly is the ambit of the constitution. If we are going to make personal laws also a subject matter of Article 21, then it will become very difficult. There is a T. Sarita versus Ashwini Kumar, which is a case of restitution of conjugal rights, where a party was saying that my right to privacy is violated and my Article 21 is violated because the court is forcing me to live with a spouse that I don't want to live with. The court said that you cannot exercise your right to life and personal liberty because it is a marriage we are talking about, and there are a lot of multiplicity of factors that need to be taken care of. So there is no place of constitutional law in a marriage. Two separately married live together. I don't know what this means. Is it mandatory to undergo a period of 1 year? No, I just told you. It is written in the presentation also. The court can waive off the 1 year period. Rape by husband, is it criminal? Yes, if the husband rape by husband of somebody else, marital rape is not a ground for divorce. If you want to get a resolution in the form of marital, because a marital rape is happening to you, you can approach the court in DV or you can approach the court in cruelty and say that physical cruelty has happened. But even then, you will only get divorce. The husband will not go to jail. Yes, it is a ground for divorce. Rape by husband is not criminalized. Rape by husband, if the husband is charged and punished for rape of somebody else, not the wife. Divorce filed under section 13, can the judicial... Okay. Judicial separation is the only decree which is given as an alternate to divorce. If you go ask for divorce, the court will tell you, no, undergo judicial separation first. Will they provide divorce of a child if is born? The case of marital rape is fine. Marital rape doesn't exist in India. There is no such thing as marital rape. If your spouse is treating, first of all, rape in India is a very sex based, gendered, not sex, gendered offense. In India, men rape, women don't rape. So if you talk about marital rape, you are saying that husband is raping the wife. This doesn't exist. It could be cruelty, it could be DV, domestic violence, nothing in the form of marital rape. What happens if I'm from Uttarakhand, UCC and WOS? How are the professions different? Well, in that specific respect, because UCC has come, they have come up with how it will be implemented also. So I'm sure that it will be subject to the implementation of those laws, right? What can we do when the wife does sign mutual papers, but every time during the tendering of the court, she denies the divorce? What can be done? The court is smart. It has judicial wisdom. It has to evaluate the case on its merit. 6-month-old marriage can be filed for breakdown? No. Minimum 1 year. Unless circumstances are such that the court will entertain the petition. In the time frame of 1 year, filing for a Christian, what is the act for filing divorce? You can go by the Indian Christian Marriage Act. What is the use of judicial if there is option of divorce from the point of view of lawyers, as well as how could we make it useful for a client? Well, judicial separation is when two people are still married, they are spouses, they both have mutual rights and duties of inheritance. So if there is any kind of property which is attached, if any kind of liability or is attached, you can still claim over it. Judicial separation is not putting an end to a marriage. When marriage ends, you are severing ties with each other. You're severing ties of inheritance, custody. Maintenance has to be decided. Maintenance has to be then figured out as well. And also, like I said, you want to make sure that the parties have ample opportunity to reconcile. Procedure of 6 months of cohabitation is also mandatory? No, the court can waive it off. Couple under judicial can reconcile after approaching the, they don't have to approach the court. The court, I mean, they can approach the court, obviously. If you are judicially separated, you are saying that you will not cohabit with each other for a period of 1 year and then you ask for a divorce. But if you are resuming, the court will rescind your decree that ठीक है अब तुम judicially separated भी नहीं हो. One party agrees, so then the divorce can happen. The court will take it on its merit. There are grounds for divorce. Husband is saying wife is cruel. Husband has to prove wife's cruelty. Husband is saying wife is renounced the world. Husband has to prove the renunciation. Only then can divorce happen. Denial is not an option. Urdu terms in Dissolution of Muslim Marriage Act? No. Great session, really enriched. Thank you. Firstly, why the grounds of the reason is that when you ask for divorce, you are asked to be judicially separated first. It is step one. You go for divorce, court is like, pehle jao, judicially separated raho, 1 saal, uske baad aana. Because it is giving you time to think about it. That is why the grounds are same. Because think about it, both of them are eventually putting an end to the marriage. Judicial separation, may you are separated for a period of 1 year, you're not living with each other, you're not cohabiting with each other, and you are headed towards divorce. You realize that judicial separation is not the end. People can't always be separated. They ultimately go to divorce. Under Hindu divorce, is there any ground regarding the imprisonment of spouse for a period of 7 years or more like Muslim marriage? If the husband is found guilty, husband only, husband is found guilty of rape, sodomy, and bestiality, then the wife can ask for divorce. Under the Muslim Dissolution of Muslim Marriage Act, if the husband is found, not just found guilty, is sentenced for 7 years of imprisonment or more, which happens in cognizable offenses only, then the wife can ask for a divorce. Couples stay forever under judicial separation without, I mean, yes, they can, but they have to be separated. That is the important thing. But the court asks, the court will not leave you judicially separated. The court will ask you to come and vouch for your separation. What will be the, 1 second. Uh, so section 25 is talking about permanent maintenance, which is alimony, right? Permanent alimony. During this time, permanent alimony is only awarded. So it happens in three ways. There is a gross sum, there is a monthly sum, and there is a periodical sum. Court is of the opinion that after divorce, it is in the best interest of both the parties that this is how it must be done. So it happens according to section 25. What will the scenario of the divorce granted again, couple gets married again? It happens quite often. I mean, I know a couple of my students whose parents got divorced after being married to each other for 22 years, and they were divorced for 2 years and they got married again. What will the court do? The court's job is to entertain petitions. Mandate if this is why it is not a subject matter of law. It is very personal in nature. If two people want to reconcile their marriage even after divorce, let them. It will not be the previous marriage, it will be a different marriage. Yes, divorce and alimony are interwoven. It is true. Is there, if there has been cruelty, prolonged periods, so can we file for divorce so long we have to not condone the act? Well, the court says that you should not condone the act of cruelty for a long period of time because then it is said that you were okay with it. So, like, let's say the wife is in the habit of taunting, the wife is in the habit of asking for, get me more money, give me more material possessions. All of this can be also can be construed as cruelty. But if the husband is okay with it for a prolonged period of time, 2 saal, 3 saal is fine. 2 years, 3 years is understandable because you were in the hopes of trying to understand, trying to figure out what this person is actually like. But even after that, if you have condoned it for a period of 10 years, the court is like, not cruelty, you are okay with it, go away. It's a matter of fact. Yes, it is. Need PPT of the session? Please ask the moderator. I will share it with you. What is the practically the least time needed to obtain the decree of divorce from a court? 6 months ish. I mean, you have to be married for at least a period of 1 year to ask for divorce. If the husband cheats on the wife and lives with wife of other person, can he still file for divorce for cruelty? He can file. He will not get the divorce. Time limit of filing for divorce if the husband noticed wife is doing adultery. Having to notice it is not equivalent to having to prove it. I find out that my husband is cheating on me. I have to go to the court and prove that he is cheating. Adultery, give divorce. Can an impoverished husband after divorce, after, about husband after divorce from wife, the husband asks, huh, interim maintenance and permanent alimony is not subject to gender. Both the parties are entitled. The court has to keep in mind what is the status of the parties, what is their standard of living, who is in a better position to pay, and what is the if they don't have any independent source, if they have independent source, can they get from their families? Court will decide that. Can we amend divorce petition if previous lawyer has not come? I am really not in a position to answer this question. I'm sorry. You must ask a lawyer. I mean, I am a lawyer and an advocate, but I don't know. Res geste is also there. Na? I mean, if you are going to change the material facts, only then can you approach the court over the same matter. Divorce step by step in family court, like filing, sending notice to partners, sending notice to etc. Is there a question here? Uh, how much time does it take for court? Well, sir, it depends. It is not something uh, which is straight jacket. Usually family courts want to not prolong this for a long period of time, depending upon the facts and circumstances of the case. I'll give you an example of a friend of mine who recently got divorced in the civil court here in Ahmedabad, Gujarat. So they filed for divorce and the court asked for both the husband, and it was divorced by mutual consent. The court asked them to be present in 3 sittings. The court did 3 sittings and then decided on giving them a divorce. So it started off in December, but they got the final decree of divorce in April. but they were contemplating divorce for a very long period of time. They got it by mutual consent because they were able to prove that we were separated for a period of more than 1 year. Need to know the steps as advocate manipulate. Yes, advocates tend to do that because it is pertinent to their case, maybe. Who knows? What if all the criterias or say the grounds which are applicable for a woman to defend herself, say the current situation in the country prevails in such a manner where men even faces many issues like, well, there is a fault in the system that some things are very gendered, like rape is a gendered provision, is a gendered penal offense. Men don't get raped, women don't rape. So it is very, very, it's a discussion which is going to go somewhere else entirely. But yeah, laws need to be amended. I'm not going to say that, but Article 15, Clause 3 says that the state can make laws, especially for women and children. And we are still pretty much quite there, where it is important for the upliftment of women and children that there are specific laws that are made to be catered to only that specific vulnerable section of the society. Um, Marital rape is being discussed quite a lot. Have you ever wondered why marital rape has not been criminalized yet? Because if people here who go to the court who are asked to state the maintainability of petitions, and if there are law students here who've done moots, then the first issue generally is maintainability of your petition, and that maintainability is on one first and foremost ground is, have you exhausted other remedies that are available in the law? Only then have you approached the court in this specific petition. Marital rape doesn't need to have a separate provision because we have other provisions which are present. First of all, you can get a divorce. Second of all, you can go and ask for a remedy which is in the form of imprisonment or fine or compensation in DV as well. That is why we don't need a separate provision for marital rape. And also, marital rape is recognized if the husband is engaging in uh, involuntary sexual intercourse with a wife who's under the age of 15 years. That is there. Two consenting two consenting adults live in. Is it allowed for two married couples to live in with? Are you asking about live-in relationships? Live-in relationships are not marriage. They are in the nature. They are relationship in the nature of marriage. This is done so that children that are out of this specific union can be considered as legitimate and they can have rights of inheritance from their parents. But live-in relationship is not a marriage. It is a relationship in the nature of marriage. Can marital rape be quoted under mental cruelty for divorce? It can be quoted under physical cruelty. Are such live-in relationship legalized? It law recognizes them as a relationship in the nature of marriage. That is it. Husband is on fault, but he is impoverished, and then he'll be liable for maintenance or not. He is be liable for maintenance, but not a lot of maintenance. The court will evaluate how much maintenance must be awarded. Any other questions, anyone? If he is liable, he is at fault, but he can't maintain himself and he is coming out of a marriage, he will get maintenance. You can ask the court to uh, subpoena the records, the bank statements. Court needs to know your individual source of income, your whatever is your spending, because the court will have to determine the quantum of maintenance. If the party is not providing, you can ask the court to force the party. You're welcome. Are there any other questions, anyone? If that would be all, moderator, can we call this off?
Sure, ma'am.
Thank you.
Ma'am, for conducting such a wonderful session. The Legal Expatriate team is really grateful for your time and efforts. And it's been a wonderful session with you. Thank you so much once again.
Thank you so much.